Let's get back to Special Prosecutor Angela Corey. Last week, you said that she doesn't have the evidence to file a second-degree murder charge, but she has not yet released all of her files. What makes you so certain that her evidence is, as you have said, quote, so thin that it won't make it past a judge?
Well, the first piece of evidence that we've seen is the affidavit by the police officer, and that affidavit doesn't even state the elements of the crime. If I had been the judge, I would have thrown the case out immediately based on that affidavit. It just doesn't state anything that would show that any crime was committed. She may have additional evidence that she's hiding, but that's not the job of a prosecutor. This isn't poker. You don't hold 2 or 3 cards down and then reveal them as the betting goes on. If she has evidence, she should reveal it. And by the way, she has an obligation not only to reveal evidence that suggests guilt, but also that suggests evidence. She's already withheld that. As far as we can see, excuse me, she was aware of the ABC and other photographs that showed bruises and bloody head on the part of Zimmerman, and that was not in the affidavit, and she did not disclose that information when she sought a second-degree murder information or indictment. Already that violates very important principles of fairness in law.
Now, do you believe that she should remove herself from this case?
I think she should be removed from the case. I don't think she should ever have been appointed for several reasons. Number one, when a special prosecutor is appointed, their job is to get Zimmerman. Get Zimmerman. That's their one job. That shouldn't be the job of the prosecutor. Second, she has a terrible reputation in Florida for overcharging and being political and holding her finger to the wind and seeing which way the wind is blowing. Then she made that statement that she's seeking justice only for the family of Trayvon Martin. She should not be the prosecutor in this case.
Explosive claims today from a man said to be the best-known criminal lawyer in the world. Alan Dershowitz railing against the prosecution, the second-degree murder charge against George Zimmerman, the Neighborhood Watch volunteer, who is now charged in connection with the death of Trayvon Martin. Mr. Dershowitz is a Harvard law professor who has argued nearly a dozen cases before the U.S. Supreme Court. He is the man who successfully got the conviction of Klaus von Bülow overturned, among many, many other famous cases. And now he is here with me on the set. Professor Dershowitz, it's an honor to meet you in person.
My pleasure.
And you are now saying that if anybody should be criminally charged in this case, it is the prosecutors. Why?
Well, first of all, anybody who is involved in a shooting should be investigated, and perhaps there should be charges against Zimmerman. So let's put that aside for a second. But this affidavit submitted by the prosecutor in the Florida case is a crime. If she, in fact, knew about ABC News's pictures of the bloody head of Zimmerman and failed to include that in the affidavit, this affidavit is not the truth, the whole truth, and nothing but the truth.
Why do they have to put in there? Why do they have to, and there's the picture. Why do they have to put in there the evidence that is bad for their side?
Because they're prosecutors, and prosecutors, when they submit affidavits, have to tell the whole truth, not just a partial truth. A half lie is a lie. And by suggesting that, as they do in this, Zimmerman confronted Martin and a struggle ensued, the passive voice, without describing the fact that there is evidence that during the struggle, Martin may have been on top, Zimmerman on bottom, and the bloody head may have been caused, according to Zimmerman, by the banging of his head against the ground. You can't leave that kind of evidence out when you're seeking to indict or inform against somebody. That's a half-truth.
Just educate the viewers, because I think most of our viewers assume that, you know, you've got the prosecution, they have one agenda, you've got the defense attorneys, they have a different agenda. That's not necessarily true. The prosecution has a different goal.
Prosecution's job is to present the truth and the whole truth. It has obligations under the law not to suppress evidence, not to hide exculpatory evidence, and to seek justice. Not to seek justice for Trayvon or for Zimmerman, but to seek justice for the entire society. That's their job, to make sure that there is a just result. Now, I've heard from some, well, the prosecution has more evidence, but they're holding it back. This isn't poker, where you hold 2 cards and you flip them later. This is the justice system. And the justice system has to be resolved by our usual procedures. Better 10 guilty go free than 1 innocent be wrongly confined, proof beyond a reasonable doubt, and all the evidence of innocence must be set out by the prosecution. The United States Supreme Court has said that repeatedly.
But they will. They'll do it at trial. They have to do it in the probable cause affidavit.
Too late. You don't indict based on false information. Now, one of the problems is because they've indicted for second-degree murder, and there's nothing in this affidavit that suggests second-degree murder, the elements of second-degree murder aren't here, the expectations have been reduced. There was an article today in one of the Daily Beast saying there'll be riots on the street if there's an acquittal. If there are riots, it will be the prosecutor's fault because she overcharged, raised expectations. No reasonable jury is going to convict based on the evidence I know of second-degree murder. So this prosecutor not only may have suborned perjury, she may be responsible, if there are going to be riots here, for raising expectations to unreasonable levels.
Do you think, you know, she went down there to Florida, or she's in Florida, but she went out and when she announced these second-degree murder charges said, we are here to seek justice for Trayvon, That raised a lot of eyebrows because is it justice for Trayvon or is it just justice?
It's just justice.
Because Zimmerman is claiming that it was self-defense, that he was the victim in this,
this is not the first time this speech has been made. It was also made in the Anthony case, where the prosecutor said, we need justice for Kaylee. And the jury said, no, you need justice for the defendant. There's only one person on trial. And that is the defendant, George Zimmerman.
But
only
Kaylee,
one person who has rights.
Because Kaylee, you knew Kaylee Anthony was a genuine victim.
Right.
There was no question. Trayvon Martin appears to be a victim, but we don't know. Zimmerman's whole defense is that he was the victim.
Look, they may both be victims. Trayvon Martin was a victim. He was not committing any crime. He was carrying Skittles. He shouldn't have been followed. He shouldn't have been confronted. But if, in fact, Zimmerman is telling the truth that he was blindsided, that Martin turned from a victim into an assailant, you may have two victims, two provokers, and a very complicated legal issue that always must be resolved in favor of the defendant. When in doubt, you always resolve those doubts in favor of the defendant.
But I want to ask you, because this is one of the questions I've been asking all along. Can you get to second degree if you can prove Zimmerman stalked Trayvon? Zimmerman had no right to do that. Zimmerman ascribed criminal motives to him that were not appropriate.
Absolutely not.
Zimmerman then abandoned pursuit, but was confronted by Trayvon. But the only reason he was confronted by him and forced to engage in self-defense was because he was the initial aggressor in stalking, following, etc.
No, the statute's very clear. If you're the provocateur, let's assume under your hypothetical that Zimmerman was the provocateur, you lose the stand your ground statute, but you don't lose traditional self-defense.
So even if he can argue it in front of a jury, but it's not going to get him out of the criminal trial altogether.
Well, it might. It might get him out of the criminal trial because the stand your ground statute gives the judge the right under the general statute to look at the law. Any reasonable judge should throw out second-degree murder. And now we're down to manslaughter. Then you have to ask yourself, is there enough of manslaughter? Not in this affidavit. There may be more evidence that the prosecution now has. But my great fear is that the prosecutor has raised the stakes, has raised expectations, and she may be responsible for whatever the results are if there are going to be an acquittal, which I suspect there will be in this case.
Why did she do that?
Because she's a politically elected person who was appointed to get Zimmerman. She was appointed to prevent riots. She wasn't appointed to do justice. She was appointed to calm the situation down. That's the problem when you elect prosecutors. We're the only country in the Western world that elects prosecutors. Prosecutors run for re-election based on how many people they put in jail. That doesn't produce justice.
We saw that problem. I'm not saying it applies here, but we saw that problem in the Duke fake rape case with Mike Nifong, who was running for re-election.
What happened to him. He went to jail for a night and got disbarred. If I were this prosecutor, I'd be hiring a lawyer at this point.
Wow.
For a night and got disbarred. If I were this prosecutor, I'd be hiring a lawyer at this point.
Wow.
If I were this prosecutor, I'd be hiring a lawyer at this point.
Wow.
Professor Alan Dershowitz. Professor, I've really looked forward to this conversation. You've seen the affidavit of probable cause. What do you make of it?
It won't suffice. Most affidavits of probable cause are very thin. This is so thin that it won't make it past the judge on a second-degree murder charge. There's simply nothing in there that would justify second-degree murder. The elements of the crime aren't established. Basically, what's in the affidavit is what's in the public domain, with the exception of the few little things that were put forward by your previous commentator. But the fact that the mother identified the voice as that of her son, of course, we all know that that was going to happen. There's nothing in there, of course, either about the stains on the back of Zimmerman's shirt, the blood on the back of his head, the bloody nose, all of that. It's not only thin, it's irresponsible. I think that what you have here is an elected public official who made a campaign speech last night for re-election when she gave her presentation and overcharged, way overcharged. This case will not, if the evidence is no stronger than what appears in the probable cause affidavit, this case will result in an acquittal.
Professor, you and I have the benefit of having read the affidavit. Allow me, please, just to read one short paragraph so that folks know how limited it is in a factual discussion of the critical sequence. Zimmerman confronted Martin and a struggle ensued. Witnesses heard people arguing and what sounded like a struggle. During this time period, witnesses heard numerous calls for help, and some of these were recorded in 911 calls to police. Trayvon Martin's mother has reviewed the 911 calls, identified the voice crying for help as Trayvon Martin's. Nothing about that critical, who struck the first blow and what precipitated that action that I was looking forward to seeing in the affidavit of probable cause.
But it's worse than that. It's irresponsible and unethical in not including the material that favors the defendant, unless it's not true. But if it's true, as we now have learned from other information, that the grass stains are in back of Zimmerman's shirt, that there are bruises on his head, you must put that in an affidavit. The affidavit has to tell the truth, the whole truth, and nothing but the truth.
Let me ask you this, because you've written something very insightful about the nightmare scenario that a prosecutor could face, where you distinguish between the differing levels of proof, probable cause, as compared to beyond a reasonable doubt. In lay terms, lay that out for us now.
Well, it's very easy to get an indictment. I think a chief judge in the New York Court of Appeals once said that a prosecutor could persuade a grand jury to indict a ham sandwich. It's even easier to get something like this because all the prosecutor has to do is sign her name to it. But probable cause is a very minimal standard. It just means if everything that you say turns out to be true, have the elements of the crime been satisfied. Proof beyond a reasonable doubt means that a jury has to conclude that there's no doubt that it happened, no reasonable doubt that it happened. This affidavit doesn't even make it to probable cause. Everything in the affidavit is completely consistent with a defense of self-defense. Everything. Even if he was the provocateur, you still have traditional self-defense under Florida law. If, in fact, Zimmerman provoked it, but then Martin got on top and was banging his head against the ground, he still has a traditional right of self-defense. So there's nothing in this affidavit, and I've read it quite carefully, that suggests a crime. It suggests the possibility of a crime, but a good judge will throw this out. And I think probably she'd be satisfied with this. She, she's won her campaign. She's overcharged, second-degree murder. She's the hero.
Well, Professor, will the prosecution get a mulligan on this? Will they have the opportunity to do it over and put more information into it?
Sure, but the question is, do they have more information? If they had more information, why did they put it into it? And why are both sides trying to seal the record here? I suspect that already we're seeing negotiations
for a plea?
Possibly toward a plea bargain. The new lawyer implied that yesterday when he talked about negotiations and when he wouldn't say anything critical about the prosecutor. But, it's unethical to overcharge in order to get a plea. It's unethical to charge second-degree murder in order to get a plea of manslaughter. And so I think this prosecutor has a lot of answering to do. She'll win a lot of popularity contests. She'll probably get appointed a judge. But the tragedy in America is we're the only democracy in the world where we elect prosecutors and elect judges, and that's not conducive to doing justice in high-profile cases where people are rooting for outcomes and nobody seems to be concerned about the truth, except, by the way, Martin's parents, who seem to be handling